Well, it is Friday, and I am back in the office. I was in Monmouth County, New Jersey, representing a client this morning. Actually, spent most of the day in Monmouth County. Now back in the office in Moorestown, New Jersey, to see some clients before I finish out the week. It's been a very busy week for our law firm, as always, in Pennsylvania and New Jersey. Put out a blog article regarding domestic violence in New Jersey. And New Jersey, like many states, including Pennsylvania, has a system to deal with domestic violence. It obviously sadly happens in all over the country. And in New Jersey, the process is what we call restraining orders, and there can be temporary restraining orders and final restraining orders. Now, temporary restraining orders can be accomplished any time of the day, even on the weekend. In fact, a lot of domestic violence claims are made on the weekends and they're done at police stations. So if it's after hours or it's on a day where courts aren't open, the victim of domestic violence can go make a complaint and actually see a judge, and that judge can issue a temporary order. Now, obviously, the order, just as the name implies, isn't a permanent order, and then that requires a final restraining order hearing. Now, at a final restraining order, the victim must allege and prove by a preponderance of the evidence what's called a predicate act. And what that is just an act of domestic violence. It can be pretty much anything, including stalking, harassment, obviously things like assault, aggravated assault, simple assault. I think I said stalking already, but any type of physical or even non-physical violence, terroristic threats, all that would fall under the Domestic Violence Act in New Jersey. Now, once that act is established, the court has to determine whether or not a restraining order is needed to protect the victim from further harm. So it's a two-pronged test in New Jersey. It's not a criminal courtroom. So the standard isn't guilt beyond reasonable doubt. It's a lower evidentiary standard the plaintiff has to meet. But nevertheless, it's the plaintiff's case. So whether our law firm is representing a plaintiff or the defendant, the burden is on the plaintiff and acting like the prosecutor would act in a criminal case, but except the burden of proof is much lower. Now, the defense has an opportunity to put on its case and to call into question the credibility of the witness, or whether or not the plaintiff has actually met the standard under what's known as the silver standard in New Jersey. But if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey. Have a great weekend. Before I leave, though, I'm going to give my weekend advice. If you are stopped for suspicion of DUI in Pennsylvania or DWI in New Jersey, do not refuse the chemical test. It'll never help your criminal case. If the police want to search your car, don't get in their way, but never give consent, whether you're in Pennsylvania or New Jersey, to search your car or your vehicle. Once you give consent, you immediately give up your constitutional rights under the state and U.S. Constitution. You don't want to do that. But once again, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey. Have a great Friday. Have a great weekend, and I'll talk to you all very soon.